Kwabena Boahen and his wife, Angela J. Boateng, are tied to alleged corruption in the procurement of cyber defense software. The software, acquired under a $7 million contract with Israeli company ISC Holdings, is at the center of financial mismanagement claims. Investigations indicate that Boahen and his wife, through their privately owned company, BNC Communications Bureau Limited, transferred the contract sum equivalent to 49 million Ghana cedis into their company's account instead of remitting it fully to ISC Holdings.
The funds were reportedly disbursed in tranches of 27.1 million Ghana cedis, 1 million and 21 million Ghana cedis into BNC Communication Bureau Limited's account. However, only 9.5 million was actually paid to ISC Holdings to execute the contract. Attorney General Dr. Dominic Ayine explained that Boahen and his wife personally benefited from the transaction, allegedly diverting 39.46 million Ghana cedis.
That is to say that the sum of 39,462,480 Ghana cedis of taxpayers' money went into their private pocket.
Dr. Ayine also provided updates on ongoing investigations into the oral report, which highlights financial irregularities at the National Service Authority, as well as payments made under the controversial SkyTrain deal.
But I can confirm that investigations will conclude in the National Service and SkyTrain scandals by the middle of April for prosecutions to begin. In the National Service scandal, 8 suspects have been interrogated, and a good number of them have started singing. They are cooperating with our they've started singing, literally. Yeah. So we will give you details of their songs at the appropriate time.
Right, let's now speak to Deputy Attorney General Justice Srem-Sai for more on this Kwabena Boahen case. Thank you very much, Justice, for joining us.
Thank you very much, Prima.
Now, based on the evidence disclosed at the press conference regarding the Kwabena Boahen case, when should we expect the state to arraign the two?
Let's say in 2 weeks we should be able to make our first court appearance.
Right now, is the concern limited to just the diversion of funds, or the substantive contract has issues as well?
What we have now is not about the validity of the substantive contract.
Okay.
Yeah, so at this point, what we are looking at is the use of the funds or the misapplication of the funds. And as the Attorney General indicated during the press conference, the more you look at the evidence you have, the more links or connections you see, you discover. And so that is why I was not exactly able to give you the specific time, because every time we look at one company and we look at the transactions that the company did, it leads us to another company. And that is how come we discovered these number of companies. A very complex web of company arrangements has been put in place. And a very complex, these companies are engaged in various industries and businesses. And so you would see that while one of the companies would be, for example, into real estate, the other one is into maybe agri, and then one is into advisory services, then it leads into the United Kingdom, and then you see something else. And so that is how come we keep discovering new things. And those who are very familiar with investigations or forensic investigations, you would want to get some conclusion at a point to be able to step, into court and start the prosecution. For what we have discovered so far, as the Attorney General said, there is sufficient information or there is sufficient evidence to start prosecution. However, with the new discovery, we want to see a clearer picture to be able to rope in those that would have to be roped in, to be able to gather even witnesses out of some of the suspects, because as you know, sometimes a suspect may be converted into a witness for the prosecution to be able to get to the bottom of the matter. So it is quite interesting to note how these investigations are going. But like I said, there's enough evidence to start the first issue of misapplication of funds.
Right now, lawyers for Mr. Boahen claim that his rights have been violated by you going to the press, arguing that this really prejudices public opinion against him. How do you respond to this?
I think the concern is something that I can understand. I can understand why they are arguing that it is prejudiced. But if you and that is the reason why if you look at the way we do the AG move, we don't. There are so many things that we don't talk about. We've done searches. We've invited more than 50 people in this oral in police station to give statements. We've interrogated them, but you only get to hear of a few, and the few that you get to hear of often come out as a result of maybe the MPP parliamentary caucus holding a press conference or from. But the investigators themselves and attorney generals, we don't come to tell anyone anything. That is because we appreciate that some of these allegations, when they are brought at a certain stage without sufficient evidence, may prejudice or even maybe the same people. So we are very much aware of that, and we share that sentiment, and we have done everything not to do so. However, in this particular case, I think the evidence is enough to let the public know. We are using public power. We are accountable to the people of Ghana. We believe that to enhance democracy, and with the amount of evidence we have, this is a proper way or a proper situation to let the people of Ghana know how much has gone on. And so when we balance the personal interest as against the public interest in terms of this, and we consider it, we put it in the light of the amount of evidence we have, we believe that there is a justifiable basis for us to let the public know this. So in as much as we believe that sometimes disclosure of certain things would prejudice or even bring down the reputation of the people involved, we believe in this particular case, we are justified to let the people of the country know.
The lawyers also deny allegations that he disguised himself upon entering the country because, according to them, it makes no sense. He could have used any other route other than the Kotoka International Airport. What is your reaction to this?
We have let the public know what has happened. They believe that he was not disguising, or he was, I think the proper word is he was not trying to mislead investigators. That is what they believe. But I think at least they are not denying the fact that he had changed his flight. They have not denied the fact that he had booked a different part of the plane as contrary to his usual, means of travel. They have also not denied the fact that the name he used is not his usual name when he was getting the flight, the British Airways flight to Ghana. So these facts are not denied. If they are not denied, they may choose to conclude or draw their own inferences. But I think we are also entitled to draw our own inferences from those facts. And if our inference is that it's an attempt to evade arrest, they obviously are also entitled to think that it is not an attempt. But the key thing that we should all be focused on is the fact which they cannot or they have not been able to dispute. And I think that when all is said and done, these matters go to the basis of even when you are granting bail, you have to consider certain things. You have to consider what we call the flight risk, the mobility of the person. How easy is it for the person to leave and come to the country? How easy is it for the person to hide and not be found? This person we are dealing with is someone who has multiple passports already. He has enough funds, as we have shown, to actually acquire foreign nationalities, and we are not yet sure whether he has, but we think that he has the capacity to do so. This person's travel history also shows that he is very fluid when it comes to moving across international borders. And even in Ghana, for his previous position that he has held as a security intelligence official, it is also very obvious that he has what it takes to beat the system and play around a bit. We take all these things into account in determining whether the person will be granted bail and the terms or the condition under which the bail should be granted. And I think you probably will be aware that the court also takes into account these matters. So many times the court will say, drop your passport or bring this and report this number of times. We believe that these are all part of the things that we considered in arresting and granting bail. And so if the defense lawyers are of the view that we should ignore these things in our assessment of the person's flight risk, we believe that we are entitled to consider them, and it will inform how we deal with the situation.
Now, Justice, the lawyers also alleged that he was denied access to legal counsel at the time of his arrest. Can you clarify what transpired?
Thank you. I have spoken with the suspect. I don't know if the lawyers would admit that, but I have met him personally. I have spoken with him. That was a few hours after his arrest, and I asked him about these questions, and he told me that he's been given all the necessary support. And at the time I was speaking with him, his lawyers were around, and so when he says at the time of arrest, when the lawyers say at the time of arrest, I don't know whether they meant that at the point of being arrested, the lawyer should be there before he's arrested. I don't know if that's what they meant. If that's what they mean by at the time of arrest, he wasn't given the right to counsel, then that is a bit strange, because I mean, if I want to arrest you, I don't think the right to counsel means that your lawyer must be there before I take the arrest. My understanding of what right to counsel means, and I think I should be given some significant credit of that, of what the right to counsel means. It means that before we speak to the police officer, before you answer any question, or before you have any communication with the police officer, you are entitled to have your lawyer present. Yeah. So the right to counsel begins when, it's good if you have it at the point of arrest, but it begins when we are trying to have a communication with you. It begins when we are trying to take evidence. That is where it begins. But I don't think it means that before we arrest you, your lawyer must be there at the point of arrest. I don't think that's what it means.
So does that mean that before questioning began, his counsel was present?
Oh yes. Before we did any evidence gathering, thing, the counsel was present. And indeed, at the point of arrest, we have a duty to inform you of your, we call it Miranda rights, that you're under arrest, and you have the right to remain silent, and everything you say or do may be used as evidence against you in the law court. That is one of the things that we investigators or arresting officers are very familiar with, and they do it before. So, and even from this statement, it shows that we acknowledge that we don't need a lawyer. I mean, the lawyer needs not be there at the point of arrest, but we need to inform you that once you're arrested, anything that you say or do may be used as evidence against you.
Well, very well. Thank you very much, Deputy Attorney General Justice Srem-Sai. We'll come back to you for more updates as and when necessary.
Thank you very much, Srem.